unsuccessfully, for the most part, starting with the Warren Court in the 60s, is they have made social policy through the guise of Supreme Court interpretations. That's what they have done. They are an unaccountable branch of government. The two so-called political branches of government are the legislature and the executive, the president. They are politically accountable. If the people don't like what they're doing, they can be thrown out and even impeached. The Supreme Court, indeed the whole federal judiciary, the district courts, the courts of appeal, and the Supreme Court are untouchable. They are life appointments. Nothing can be done. There's nothing that they would do that would suffice to be an impeachable offense. So they are there forever. They can do whatever they damn please, and they do. And what they have done is they have treated the Constitution like a statute or an ordinance on a local level, which can be amended, changed, repealed, whatever they want to do with it, not understanding, or maybe better, not caring, that it is the fundamental charter of government. There is a textual mechanism for amending that Constitution, that it shouldn't be, although it has been, amended through what purports to be legitimate interpretation. That's this notion of a living Constitution. Living. So you just water it and hope it grows here, and you hope it grows there. And that's a pernicious doctrine. It has done an incredible amount of harm, particularly in the areas of the Fourth, Fifth, and Sixth Amendments, which contain the criminal procedure provisions, like self-incrimination and double jeopardy and search and seizure and the rest.
Isn't it also true that one of the pervasive or insidious parts of calling the Constitution a living, breathing, changeable, malleable document is that through incrementalism you can alter everything?
Well, yes, and unfortunately, because incrementalism is a little sneaky,
That's what I mean.
If you're not paying attention, you wake up one day and you say, what happened? But it's so brazen, so often, they don't even have to do it incrementally. I mean, take capital punishment. Capital punishment, the death penalty, is mentioned, 4 or 5 times in the Constitution. Supreme Court held back in the Brennan-Warren era that it's unconstitutional. Something provided in the Constitution is unconstitutional. Now, that wasn't incremental. I mean, they just blew it away, to put it colloquially. Mm-hmm. So it's certainly the incremental ism is one aspect of it, and it's pernicious. But sometimes they just take it head on. They say, we're changing the rules. I mean, what does the Fifth Amendment say about having to, with the self-incrimination provision of the Fifth Amendment, say about having to tell someone in custody that he's entitled to a lawyer? Well, they say it's not fair. I mean, how would this poor guy know, putting aside that all the criminals knew anyway, to keep their mouths shut? No, we have to tell him. Well, okay, so he's got a right to a lawyer. They say, well, but wait a minute. He may have a right to a lawyer, but where's he going to get one? They say, oh, well, now we're going to have to tell him not only has he a right to a lawyer, not only does he have a right to keep his mouth shut, but if he doesn't have a lawyer, we'll get him a lawyer. And wait a second, what happens while we're waiting for the lawyer to come down to the precinct? Well, we better tell him that anything he says can be used against him. Now, how do they get that out of the Fifth Amendment? I'll tell you how they get it out. That's their view of what society should do.
You mean it's not in the Fifth Amendment?
It's not, no. The Fifth Amendment says, in effect, nobody can be forced to incriminate himself. Now, what did that mean originally? That meant you couldn't beat a confession out of somebody. The touchstone of it before Miranda, the criteria, if you will, the litmus paper, was voluntariness. In other words, was a confession voluntary or not?
I don't think most of them are.
And then what they did, was they then decided that if you didn't have a lawyer, it couldn't possibly be voluntary. You could go on the Jay Leno show and confess to something with smiles and eating oysters and drinking champagne, etc., with absolutely no sense of, or an iota of coercion and confess to something, and that wasn't enough. It would be admissible if the standard were voluntariness. But even if you did that, if you were in custody, if you were like handcuffed to some cop on the talk show, it wouldn't be admissible unless they had given you Miranda warnings. Can you imagine that?
Wow.
But coming back to the central question that you asked earlier, and this is a crucially important one, why do people need to know this? People need to know this in order to make any effective arguments. They need to be imbued with a feeling and an understanding that this is not how it was supposed to happen, and it's not the way it's supposed to be, and that the Constitution in this and almost every other respect has been subverted and perverted. I mean, Brown against Board of Education, I'm jumping around, the desegregation decision of government segregation was supposed to prevent or supposed to end racial segregation in this country, and by implication, and then later explicitly, racial discrimination. Segregation is, of course, a form of discrimination. So now the liberals took over the academy, and what did they do? They started discriminating against white people by imposing quotas on how many of them could go to graduate school, say. But that was okay somehow. Because after all, we're all guilty for what happened in Georgia in 1710. Now, it used to be, and this is very interesting because I was brought up, my parents were Jewish, I was brought up in a Jewish family. In those days, in the 30s and 40s and even later, there were quotas about Jews in say, medical schools in New York and elsewhere. Quotas, actual quotas. We got to get 3 Jews for this entering class. And of course, the Jewish community was appalled at that, etc. And now it's okay with them if there are quotas on whites. I talked to an admissions director of a law school a week ago, and not to try to get somebody in, I just needed some information. So a young man called me and said he was interested in going to law school, and I asked him what his LSAT was, law school aptitude test, and his GPA, college, etc., and he told me. And I said, well, that doesn't sound great, but let me find out what schools in this country would take you with that level. So I called an admissions director at a law school here in the West, and whom I know, and I asked him about it. And you know what the first question he asked me was?
No.
Is he white? And this is a guy who...
Say that again. Tell me what the first question was.
My question was, here are the numbers. And what schools in the country could he get into with these numbers? And this admissions director here in California said to me, the first thing he said, is he white?
Why does it matter?
Her implication is if he was white, it probably wouldn't be so good, and if he wasn't white, he'd have a better chance. And this guy is not in sympathy, by the way, with quotas or racial classifications, but that's the first question he asked me a week ago.
That's pretty stunning.
Now, if that's not discrimination, I don't know what is. But that's okay because it's, quote, good discrimination. Thomas in Grutter, I think, it's in my book, makes a wonderful point about the distinction, people who try to draw these distinctions between good discrimination and bad discrimination, a discrimination in a good cause and discrimination in a bad cause.
It's going on all the time anyway, on some level, whether it's conscious or not, don't you think?
Well, yeah, but what people and this is another example of what people need to know, and an argument that they need to be armed to make, is that there's a hell of a distinction between doing that on a governmental level, which is supposed to be colorblind, and a private level. I mean, if I don't want a Swede cleaning my house, that's my business. If I don't like Swedes, the people from Sweden, okay? That's me. It's my house.